Hi, everyone. My name is Rachel Marks, and I am the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Russell O'Rourke, an Ohio construction lien law guru. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Russell O'Rourke.
Good morning. Thank you very much, Rachel. Rachel was just telling you that SunRay represents contractors, subcontractors, and suppliers. Well, there's a difference between the rights and the necessities for each one of them. So we'll go through and we'll focus on the differences between them, as well as the similarities and the things that you need to do no matter who you are to get paid on your project. If you have questions, look in your chat box over on the right of your screen. Type in your questions if you have any, and I'll just jump in and have a look just as soon as I can. If I can answer the question right then, I will. If it fits somewhere else, it'll fit somewhere else, and I'll put it in there. I'm a lawyer, and you know, with lawyers, there's always the fine print. And so this fine print, the most important part here is the very last sentence, which is you need to talk to a construction law attorney if you have questions about how something applies to you. The things you're going to hear today are going to apply generally. And I say it like that because the issue is that construction is very litigious. There's a lot of lawsuits filed. So there's judge-made law and there are statutory law. And the statutory law is frequently reviewed and decided by the judges. So just because you hear something here today doesn't mean, and because the judges make these decisions, they make it on a very specific set of facts. Your facts might be different. If you know an attorney, your cousin Vinny is a personal injury lawyer, that's great. Just don't talk to him about construction because it's so complex and there's so many different cases that affect it. You really need to talk to your construction lawyer to get a good answer as to how what you're learning today is going to matter to your case. So 10 steps to getting paid. First, it doesn't occur to people. You have to start at the very beginning. You start with a conditional bid. We'll talk about that. Then you negotiate a fair contract. And here's the big one. Contracts are boring. People look at them and they say, I know what this says. I don't have to worry about it. I got my price, I got my scope, and everything's good to go. And no, there's a lot of little tiny things in there that if you don't pay attention to them, can lose your right to make a claim, to do just about anything, particularly if you're using, there's really two types of contracts. There's the standard industry form contracts like the American Subcontractors Association put together with the AGC. Those are consensus docs. And there's the American Institute of Architects. But there's also proprietary contracts, which are coming from, it depends on who you are, the owner, the contractor, the subcontractor, whoever is your customer. And make no mistake about it, they didn't write it, their lawyer did. And when their lawyer writes it, you get really backed into a whole lot of things that you weren't expecting. So have somebody, if you're really good at reading contracts, great. If you're not, maybe you have a paralegal on board, maybe you don't. Talk to your construction lawyer who can go through and give you a real quick review and highlight some things. They're not going to catch everything, but it's like, there is a subsurface condition that was unexpected. Well, what do you have to do? Can you just go ahead and handle it? Do you have to give notice? When do you have to give notice? If you don't give notice by that time, have you lost it completely? And the answer generally is yes. But so you have to follow everything that's in your contract if you want to have the better side of the argument if it ever comes down to a dispute. For subs and suppliers, you need to get a notice of commencement. In Ohio, they're called notices of commencement. In Florida, they're called notices to owner. It's the document that's filed by the project owner to tell you everything you want to know about filing a lien, who the project owner is, who the contractor is, who the lender is, if there's a bond on it, and the legal description, which if you're going to file a lien is vital. Then you have to worry about, as you're moving along, the second half of that is, and you have to serve your notice of furnishing. We'll talk about when you have to serve it in a little bit. As you're working, you need to sign lien waivers. You're going to be required to sign lien waivers, but you have to make sure that they're the right lien waiver. If they're not the right lien waiver, then you may give up too many of your rights, and because they're overbroad. We'll talk about those. Calculate your lien deadline. We'll talk about how to count the days. Be aware of start and stop job timelines. So if you have a job where you're going to do part of your scope now, and let's say you're the mechanical contractor, and the last thing you have to do is come back and start up the equipment for the fire marshal. That's all well and good, but what if you never get that call back? If you don't get that call back, the time to file your lien ran maybe months ago. So you have to pay attention and be sure that you're actually doing work and you're actually going to be back on the project. So we'll get there. Consider sending a notice of intent to lien if you're not being paid. Notices of intent to lien are not required in Ohio, but they're a very good tool to get people interested. And the people you want to have interested are, and this really is, it can be any of the parties, but if you send this notice, all of a sudden somebody starts to say at the project owner, wait, there's somebody who is going to file a lien. It's going to stop my my lending, and if my financing goes down, everything else is going to be a problem. So we need to pay attention to these people. Prepare to file a lien 2 or 3 weeks in advance. If you're going to do it yourself, that's great, but you don't want to be looking at the very last minute to find that notice of commencement again if you didn't already have it, to find the legal description, to figure out where the legal description is. We had one the other day. Client gave us an address to file a lien. This is actually file a notice, serve a notice furnishing. And the address didn't exist. It existed in the post office, but not anywhere with the county recorder. And it's a strip shopping center, but there are other pieces, and the other pieces are owned by different parties. So you had to figure out who owned the right piece in order to do your notice of furnishing. Notices of furnishing, they sound easy. They're really complex to get right. Sometimes it's just like you expected. Other times you didn't do it right, and all of a sudden you have no lien rights. So the next thing, if you're not being paid, you file your lien, you get paid, and you release your lien. Sounds simple. It's a little more complex than that, but okay. So to get this moving, you have to condition your bid. Before you have a contract, you had to bid for the project. And when you're conditioning your bid, what you want to do is pick a form that you want to use. Maybe you like consensus docs. Maybe you like AIA docs. Maybe you have your own form. You can pick if you want to, you can pick a form. If all you want to do is quantify or qualify everything that you're going to do, all the obligations you're going to have and all the rights you're going to have, you can do that too. But so if you picked a form, you specify the form. If you didn't pick a form, that's fine, but make sure that you put in all of the different pieces that are important to you that you want to have in your contract. You want to either use a form or call out in your bid that you won't waive lien rights, because you see that an awful lot of time. There is some help on lien rights. About 20 years ago, we got past the American Subcontractors Association. We got past the Fairness in Contracting Act, which is Ohio Revised Code 41-1362. Section E says that if you have a conditional payment process in your contract, you cannot also have an enforceable waiver of mechanics lien rights. So you have a pay if paid clause, they can't also keep you from filing a mechanics lien or filing a bond claim. That's helpful, but you have to look at the other things too, such as in that same paragraph with the waiver of your lien rights, you're often also indemnifying them if any of your subs or suppliers file mechanics liens. So that can be a problem for you. It can be a huge problem. And you might have to bond it off. You may have to pay it out, any number of things. One of the best things you can do also is provide a certain specific lien waiver form that you'll agree to sign. And also the next thing is then negotiate a fair contract. That's what you're all leading up to, is getting your ability to negotiate a contract. Why does that work? Because of this case. This is an Ohio appellate court case, Franklin County, Complete General Construction versus Card Welding. Card bid on a project. I mean, a very long story short, they screwed up on their bid. And they did have one condition in there. And I'm not suggesting you use this as your only condition, but they said that the bid had to be accepted within 90 days. The bid wasn't accepted within 90 days. Card had left out a huge piece. They'd left out about $100,000 of their bid. And they figured it out just as soon as they sent their bid in. They sent a revised one, withdrew the other one. The court said you couldn't withdraw the other one because you said you were going to leave your bid open for 90 days. By the way, Complete said, oh, we never got that other one. Contracting in construction is different than contracting just about anywhere else, because in general, you make an offer, the other side accepts the offer, rejects the offer, makes a counter offer, something like that. In construction, because of this massive bidding process, so you're a supplier and you say you're going to supply windows and you're going to supply them to a subcontractor who is going to rely on you to produce exactly what you said in your bid. You can't go back later and say, oh, well, I want more money. So that works at the second tier level. At the first tier level, going up to the contractor, the contractor, when you give them your bid, is going to rely on your bid to make their bid to the owner. When that happens, you made the bid, they used your bid in their bid, you're stuck. Now, the way out of that is they have to comply with the terms of your bid. If all you say is, I can do this scope of work for this amount of money, you have no negotiating power at all. They're going to turn around, they're going to give you the contract they have, and all they have to do is use terms, and it says so right in this case. All they have to do is use terms that are common in the construction industry, like you didn't want a pay if paid clause. Well, if you didn't say I'm not going to accept a pay if paid clause, they can give it to you because it's common in the construction industry. This is actually, yeah, I know I'm funny because I'm a lawyer and I like to read stuff like this, but this is really a good case to read. It's short, maybe it's 7 or 8 pages, but it shows the history of how we got from 1958 which is when the first case was around on this concept of reliance. It was a California case, Starr v. Drennan. And I like to say that a lot of laws are made in California that then infect the rest of the country. Well, by the middle of the 1960s, it had infected Ohio. And so now we went from California to, there was a Cox Plumbing versus Wargo, and Cox tried to back out. They wanted more money, and the court said, nuh-uh, technical legal term, nuh-uh, you made a bid, he relied on it, so you're stuck, you have to perform. And what happens is you're not going to perform because it's already past that date by the time you get to the lawsuit. And they have found a replacement contractor, and they are going to charge you the cost over your bid as damages, and they're going to win. It goes further. This case continues to talk about how it morphed from that first little fledgling one into what it is today, and what it is today as this concept of you can condition your bid. The things you don't use to condition the bid, they can stick you with. So be careful, but be sure you condition your bid, because conditioning your bid lets you negotiate. You get three choices. If you condition your bid, they accept your contract and they give you contract terms that you don't like. You can look at it and say, I can live with that because this is a good owner, this is a good contractor, and I expect them to pay me. I've worked for them before, and they already always pay me net 30, regardless of whether they're paid, regardless of whether they're paid, or any number of things. Or you can, anyone you don't like, anything that you say, well, this is okay, I can live with it, and there's enough money in this contract that I want to do it anyway, so accept the terms. You can try and negotiate, but if they say no, then accept the terms. You can also negotiate, and they're going to say, oh, no, you can't negotiate because we relied on your bid. And you say, no, complete general construction v. card, here you go. So now you can negotiate and try and get terms that are good for you. And they have to negotiate or go to another subcontractor or supplier. So far, so good. The last thing is you can just walk away. Like Card. Card was $100,000 shy. Card could have said, which they did, nope, not doing it for that price, I'm out of here. And you get into this case and the court says, yeah, they had every right to do that. So very important for you to condition your bid. Now you have to read the boilerplate, or it can be called the boring plate. It's hard for me to read, and I do this kind of thing. Some of the things that are important for you to look at in particular, I recommend you read everything, but you want to look at the schedule and whether they can amend it without your consent and without additional compensation. You were going to do the job in August, and they said, oh no, we're going to delay that, and the job's behind, you're going to do it in January. Well, if you're working outside, there's a difference. There may be any number of things. Oh, and also when they tell you to go forward, you may have something else in your schedule. So now you have to find more workers. You have to be sure that you can get your product. There's all kinds of things that you have to be ready to do if you don't have any control over the schedule. Notices. One of the things about notices, you'll use some of the notices. If there's a dispute, you have to give notice within a certain period of time frequently. If there is an unanticipated condition in the project, the subsurface condition you didn't know was there, you have to give them notice, and you have to know how you give notice. Sometimes it can be by email. Sometimes it has to be by certified mail. Sometimes it has to be served within 48 hours. Good luck serving a notice of a subsurface condition or some problem that's going to arise to a change order in 48 hours if you've got to do it by certified mail. So you have to be on top of things. Payment. How's payment going to work? One of the terms in payment we talked about, we brushed on, which is it a pay if paid clause? Now, there's this, I remember I said this, the payment concept has mixed in with it lien rights and things under the one statute, 41-1362. 41-1361 is its sister, which is the prompt pay law. In Ohio, it says they have to pay you within 10 days of the day they're paid. Now, it's more complicated than that, but essentially, they have to pay you within 10 days. Sometimes they'll be magnanimous in their contract and say, we'll pay you within 10 days. Well, that's good because they had to anyway. But one of the things that's important is people have wised up. They used to start off the payment clause that says it's a condition precedent that we are paid before we have the obligation to even think about paying you. Well, okay. Well, that's a pay if paid clause. What happens if you're stuck with that? You can't get paid unless they're paid. But the language that you now see starts out differently. It starts out in that paragraph and it says, we will pay you within 10 days of the day we are paid. That's a pay when paid clause. But they're there to fool you. I'm telling you. Read down 3 sentences. It's almost always the third sentence below that one that says, and by the way, the next sentence is something that's not really prudent or not really important to the concept, but it's something about payment. Then there's another one. So because I told you pay when paid is good, pay if paid bad, you read pay within 10 days, pay if paid, I stop reading. Nuh-uh. Another technical legal term. You have to read down the whole payment paragraph because somewhere in the middle, 3 sentences down, it's going to say it's a condition precedent that we are paid before we have the obligation to pay you. Now you have a pay if paid clause, despite it looking like a pay when paid clause to begin with. You have to see what your lien rights are. And so you want to read that paragraph, your lien rights, your obligations. If somebody else files a lien that works under you, and how to make that all work. There's an indemnification clause is always important. That generally says that you indemnify and agree to defend kind of everybody above you. And you want to do that. I mean, it makes sense that if you do something and somebody gets hurt or the property is destroyed, that your insurance ought to pay for it. So that's going to kick in. But what if it goes further than that and it now talks about indemnifying for contract breaches? No, you don't want to indemnify all these people for contract breaches because one of the keys that's going to kick in is who's going to pay for the attorneys for each side when you're having this dispute. If they don't have a who's going to pay for the legal fees under the disputes clause, it may be stuck right in there in the indemnification clause that says in the event that there's any claim made, you have the obligation to defend it. Now, there is a statute in Ohio that says for negligence issues that you can only indemnify them up to the percentage of your liability for the problem. So, you know, if they're 50% responsible, you're 50% responsible, your insurance company should pay 50%. But that's not going to apply to a contract indemnification. And there, your insurance company is not going to pay for those legal fees coming out of your pocket. Then there's the disputes clause. When do you have to raise a dispute? What is the type of dispute resolution? Is it litigation, arbitration? Does it start with mediation? And if it does, sometimes you'll see at the sole decision of the whoever's above you, All disputes will be resolved by arbitration in accordance with the rules of the American Arbitration Association construction law rules. That's fine, except for the first part that says at the exclusive choice of who's ever above you. No, no, no. It's one or the other. Because if it's the exclusive choice of somebody else, you can say, okay, I have to file this arbitration. I've got one right now. There's an $800,000 dispute. The contract calls for arbitration. If it were this, I get the choice of it, then we could file in arbitration and we have to pay a filing fee. It's huge. This is going to be about a $13,000 filing fee. And you don't get that money back because you certainly won't get all of it back. But if you go too long, if they hold out before they say, nope, we're going to go litigation, now you lost your money. So figure out if you like the dispute resolution process and if it is cast in stone rather than giving whoever is above you the right to select your fate. The purpose of mechanics liens and bond claims is, and this is in the, this is my language, to secure payment for the fruits and labors of your work. Mechanics liens have been around since the beginning of Washington, D.C., when the federal government didn't have any money to pay things, so it gave master contractors the rights to file liens on all of this public work that's going on. You can't do that anymore. Federal projects you can't file liens on. You can only file Miller Act bond claims. But it is to assure that you're paid, or at least give you the right to be paid. So let's look at a mechanics lien. If you are a subcontractor supplier, you have to serve your notice of furnishing. First, you want to find the notice of commencement, but you're always going to serve a notice of furnishing. Sign appropriate lien waivers along the way. We already talked about that. We don't want them to be too broad. So a lot of times you'll see a contractor, or a contractor generally is the one who's going to do it, and say to you, give me your, here's the lien waiver, just sign it, and I'll go get your money and we'll pay you. Well, it frequently says, the right one to do says, upon a receipt of a check in the amount of X dollars, whatever your payment's going to be, and when that check clears the bank on which it's drawn, this shall serve as a good and sufficient lien waiver. Instead, what you usually see is one that says, the undersigned hereby acknowledges the receipt and sufficiency of payment in the amount of X dollars and hereby waives all liens, claims, right to lien, right to claim, choses in action, and so forth. And then the second piece of it is you're waiving that, but you're also waiving through the date hereof. Are you getting paid through the date hereof? If it's the final lien waiver and you're getting your retainage, yes. If it's anything else, no, you're not. Because how does it work? You start working on day one, let's say it's the first of the month, and you go through whatever day you have to get your pay app in, whether it's the 20th or 25th, and then the contractor gives that to the owner, and the owner pays, if everything goes perfectly, pays 90% of their pay app, which hopefully relates to 90% of your payment. So you've got the retainage to worry about. But if they do it all right, they get paid in 30 days. And then the contractor has 10 days to pay you, so it's 40 days. So now you have waived lien rights. Let's say you had to have your pay app in by the 20th. So you waived the last 10 or 11 days of the month, plus 30, plus 10. No, that only works if it's the final one and you've been paid. So we have another webinar on lien waivers, so we can talk about that in more depth another time. What do you do if you're not paid? Do that notice of intent to lien. It gets people ready to pay you. And if you're still not paid, you file a mechanics lien, and still not paid, you foreclose on the lien. What do you do when you are paid? You do interim and final, for interim and final payments, you do interim and final lien waivers. You also do conditional and unconditional. So if you're doing it right, remember I said you're not going to sign the one that says I've been paid when you haven't. You're going to sign that conditional one. So you say, when I get the money, this is a good lien waiver. But you get out to the time when you're getting the money, and after you get the money, now they're going to want an unconditional one. It's still the same language that you want to use, except this one says, we hereby acknowledge the receipt of payment in the amount of, and this is a good and sufficient lien waiver. And then you have to make sure it is waiving the lien for exactly what you've been paid. And if it's not the final one where you're getting retainage, also retains lien rights on your retainage. If you've already filed the lien when you're paid, release your lien. Usually it's going to be in exchange for payment, but the statute actually says you have 30 days to release the lien. What's the point of the notice of furnishing? Well, it's the number 2 thing is to give you lien rights. You don't want lien rights. You never want to file a mechanics lien if you don't have to. What you want is you want to get paid. And what it does is it gets you on the owner's payment list. It's exactly what you want. You want the owner to say, oh, here is 123 Mechanical, and where's their lien waiver? So you get this whole exchange of things, or you get the conditional lien waiver, the owner pays the contractor pays the mechanical, and then there is an unconditional lien waiver that goes back up. That's what the owner is looking for. So if you do that, you got on the owner's list. The owner is going to work to assure that you're paid more than otherwise, because they want a lien-free job. Sign the right lien waivers. They're going to ask for those lien waivers, so do the right ones and get you payment. Those are the 3 big things, other than giving you mechanics lien rights. But those are the big 3 things that a notice of furnishing does. What is it? It's a letter, essentially. It tells them who you are, what you're doing, where you're doing it, which project, who you're doing it for. So if you're a supplier to that mechanical contractor I mentioned, you're going to say, well, I'm working for 123 Mechanical, and they're working for XYZ general contractor, and we're doing it, where are you doing it? We're doing it at the Cleveland Clinic. Well, how many projects are going on at the Cleveland Clinic? You want to be sure that you're telling them which one, so they can get you on the right list. So don't just say Cleveland Clinic. You have to say, you have to be specific enough so the contractor and the owner can say, oh, this is what this is for, to make sure you're getting paid the right amount for the right job. And you also have to say when you're doing it. So the letter form ends up, the kind of the last sentence of it says, we are doing this work, and our first day of work is or was, will be or was X date. So what that's telling them is when they have to start looking for lien waivers from you. Now, there's a bad case in Ohio. It's from the 12th district, and the court just really blew it. It was bad lawyering, and with bad lawyering, they got a bad Court of Appeals decision that said you can serve a notice of furnishing too early. We did a later one, which was in 2019 in the 9th district, it covers Summit County. And the court said, no, that doesn't make any sense. Of course you can do it before you start work. That one, they served their notice of furnishing on Friday. When you mail a notice of furnishing by certified mail, it counts from the day it's postmarked. They mailed it out certified mail on Friday. They delivered their product on Monday, and the owner got the certified letter on Tuesday, yet they said, oh no, you served it too early because it was dated, it was served as the day you mailed it. Well, there was no harm, there's no foul. If you send it 6 months early and you say, I'm sending it on April 1st, and I'm not going to start until October 1st, what's the harm? I mean, there could be a problem because your schedule might change and you might do it earlier or later. But if you're going to do it either of those, you just do an amended notice of furnishing. It's not a big deal. You would rather do it that way and not forget about it, because if you forget about it, you've lost all of that good stuff. You lost your lien rights. You lost getting on the list, all that stuff. Now, to do it right, you have to find the notice of commencement. So the best ways to find the notice of commencement is when you're signing the contract, talk to whoever you're working for and say, hey, you got a notice of commencement? Let me have it. The next thing is, if they don't have it, call the project owner. Is there a notice of commencement on this? Maybe, just maybe, you might know who the parties are. And if you do, you can try in some counties to look at the county recorder. But sometimes that can be really difficult because the county recorder's office is not like Google. It doesn't say, did you mean this one? I had one I'd seen, I knew there was a notice of commencement. I saw a timestamp copy. And when it came down to the end, I couldn't find it. I went online to look for it. And it was a Bonefish Grill, which is owned by Outback Steakhouse. And I know that Outback Steakhouse doesn't own the real estate. They have a company called OS Realty. So I looked for OS Realty. Now, remember I said it's literal. So you have a choice of O, no space, S, no space, Realty, or you have O period space, S period space, Realty, or any conjugation of that. I still couldn't find it. I tried everything. No spaces, spaces, etc. I finally called the county recorder, told them all this stuff, and they said, well, how did you spell realty? And I said, you know, R-E-A-L-T-Y. And they said, we abbreviate that. It's R-L-D-Y. Are you kidding me? You're abbreviating a proper name and you don't have a list of those abbreviations? Why are you abbreviating it anyway? It's not like it took more time. It took a quarter of a second to type out the rest of that. So anyway, there can be problems finding it. You might not have the right party to begin with. If you're working at a shopping center, like the one I talked about earlier, who's doing the work? Is it the landlord or is it the tenant? So you have to know that when you're doing your notice of furnishing. You may not know it from the document you have. You can also request it, but what I suggest you do is you request it when you're doing your notice of furnishing. This is what SunRay does so well, that they put together all these things so you're covered when you're doing this. If you did your request for notice of commencement, they have 10 days to get it back to you if you got it to the right party. So the owner has 10 days to get it back to you. If they don't get it back to you in that period of time, your obligation to serve a notice of furnishing stops and doesn't start again until they get it to you. But what if you're not really on top of things? You didn't ask for the notice of furnishing to be sent out early enough, and it's, you've got 21 days to do it. And I still have clients. I've been doing lien since 1987. And some clients still send me the request to do a notice of furnishing with 3 days left. Okay, well, if I have the notice of commencement, that's fine. If I don't, now I have to find it. And we do all kinds of searching to try and figure it out, including going to the municipality to look at building permits, to reading newspaper articles, to do all these kinds of things to figure out who the parties are so we can try and figure it out. If you're going to wait until, if you don't have it, you're going to use your best guess. And the best guess is going to be the notice of furnishing sent to who you think it ought to go to. That's when you're going to also serve your request for notice of furnishing, notice of commencement. You're going to put it in the same envelope, because if you got it right, you got it right. Now, let's go back to my client who sends it with 3 days left. So I can't find it anywhere. First of all, I had to spend a day looking for it. But then they have 10 days to get it back to you. Now you've passed the time period for full lien rights. And in Ohio, you get a kind of a makeup piece. Unlike Florida, as an example, if you're late in Florida, you're late, you've got no lien rights. In Ohio, you've got to do it within this 21-day period, but it's a sliding window. So if you served it on day 1 through 21, you're good. If you served on day 22, you've lost the first day of lien rights. If you're a contractor, it's probably not a big deal, because if you're going to get paid anything, you're going to get paid the first draw, which is going to cure most of it. So if you had that, I asked for it with 3 days left. We sent the request for notice of commencement out, and it's got to get there. You send it certified, so now you're 3-4 days there. They have 10 days to get it back, and now you have it, and you've got to get it back out again. So you just lost time. You lost lien rights. If you put it in the same envelope, you serve it as early as possible, you put it in the same envelope with the notice of furnishing, and if you're right, have somebody, the people you want to do this are, SunRay does this great. If you're going to do it yourself, you want the person who is so obsessed that every time they leave the house, they go back 3 times to make sure the gas is shut off. You want to see this so people say, oh, here it is, we've got it, and it's right or it's wrong, and let's get this right back out again. That's who you want doing all this stuff. What if you can't find the notice of commencement? Look again, ask again, consider that you made mistakes like the OS Realty thing. What projects aren't covered by this concept? There's no notice of commencement and no notice of furnishing on federal construction projects. There's only Miller Act bonds, on federal projects. Federal law trumps state law, so you have to do the federal law. I still send out notices of furnishing on federal projects, even though there's no obligation or really right to. But I put together one that talks about federal notice of furnishing, because I don't want the people who are getting it to say, what a dope. He has no idea what he's talking about. So we just created a new document that gets you on the payment list. Also, 1 or 2 family home construction projects. I have that highlighted because there's home construction and home purchase contracts. Home construction contracts, the example, you're having your house remodeled, or you're putting a deck on, something like that. There's no notice of commencement on that. Now, bank could require it because they want to be sure that they have their mortgage has priority over everything else. So they can do it, but that doesn't mean you have to do a notice of furnishing. But if you see that, you have to ask yourself the question, is this home construction or home purchase? I might have to do a notice of furnishing, but you want to do it anyway, unless you're just supplying a little bit. You know, you've got a few $100s of materials you're supplying. You're not going to file a lien over a few $100s. So if it's where you're going to consider filing a lien, then you want to do that notice of furnishing anyway, so everybody knows that you're doing the work and you're on the list. What's covered? Everything else is covered. You know what I left out? What, did I say it? Nope. Oil and gas is not covered. So if you're doing stuff on oil wells and the related stuff that goes with it, no notice of furnishing. The notice of commencement, if you can get it at all, do it before you do your notice of furnishing, but if you can't, just don't wait. Preparing your notice of furnishing and your request for notice of commencement, the best thing to do, really, I can't say enough about SunRay, is to go to SunRay and get it done. It's easy and it's cheap. for what you're doing, you want to have somebody who knows what they're doing to get it done right. And with that, they're really right on the money. And they can get everything done. If you're going to do it yourself, you need to follow the statute and follow it really closely and follow all the case law that can impair what you're doing. Always, always, always serve it by certified mail. The statute loves certified mail. If you're late, you say, oh my gosh, today's the last day to get full lien rights. So I want it there absolutely positively as fast as possible. I'm going to send it by FedEx. Okay, but you didn't send it by certified mail. It gets there the next day, 1 day late. You've lost 1 day's worth of lien rights. If you just send it by certified, it was good as of the date you mailed it. So you're going to take this receipt down and you're going to get it stamped at the post office so you know when it was mailed. So you can use that as your evidence. By the way, I have clients who call me and say, oh, we forgot to do a notice of furnishing. This fell through the cracks. What do you think? Let's not do notice of furnishing at all, because they'll never know. You know, we file a lien. They're going to talk to their lawyer. The first thing the lawyer asks me is for a copy of the green card. So if you don't have it, you're going to be toast and not have lien rights. Oh, people say, well, I can send it by email. Well, email doesn't get a signed receipt back, a written receipt back. Maybe you get back a receipt from whoever your email carrier is. But that's not good enough, because it might not have gone to the right person. The right person might not have opened it. They may have never opened it. And so that's a problem. And then the next piece is, if you really, really, really want to get it there, you can have a courier take it over. But that's more expensive than just mailing it certified mail. When do you serve it? Like I said before, you can serve it in most cases before you start work, but certainly if you can, before the end of the 21st day that you're first on the job. Well, people ask, well, what if I'm fabricating back at the office? You don't have to do it. You don't have to send your notice of furnishing in because you didn't get anything on the job yet. You can, but you don't have to. Who needs to serve a notice of furnishing? The original contractor does not. A subcontractor must, and a supplier must. And who do you serve it on? If you are the first tier subcontractor, you serve it on the owner or the owner's designee. If there's an owner's designee in the notice of commencement, that's who you're going to serve it on. If there isn't, you're just going to serve it on the owner, as it says in the notice of commencement. If you are a second tier sub or a supplier to a sub, then you're also going to have to serve it on the original contractor. So then you're going to have to serve it on two different people. I serve them on everybody. So if it's a subcontractor selling to a supplier, working for a contractor who's in contract with the owner, I send it to all the people in line. So my client's customer, so the subcontractor who I didn't have to send it to, but I want them to know that it's out there, the contractor who we had to send it to, and the owner or owner's designee. Again, serve, certified mail, certified mail, certified mail. Lien waivers, they can either be overbroad or unconditional. We talked about that. Just beware, when you're getting payment or you're going to get payment, sign the right lien waiver. When you're going to file your mechanics lien, you've got, if it is a residential project, 1 or 2 family, or a single unit of the condominium, you have 60 days from your last day of work on the job. But if the homeowner is living there, they have a paid in full defense. So you want to be sure, particularly if you're a late finishing contractor, you want to be sure to get your lien in quickly before the owner pays the contractor. Because if the owner pays the contractor, they just throw their hands up and say, sorry, already paid, take your lien off, and you'll have to take your lien off. And remember the start and stop job concept. So, oh, I didn't finish the rest of it, which is it's 75 days from your last day of work on everything else. So if it is not a public project is 120 days. Oil and gas are 120 days. But if it's anything else, it's 75 days from your last day of work on the job. And you can't stretch it. You can't say, oh, well, it didn't matter, it's just 1 day late. Yeah, well, 1 day late will void your lien. You can get them to call you back to do things and start another 75 days, maybe. And I had a client who really didn't want to file a lien, but they were coming up on their 75th day. And they had talked to the contractor who said, please don't lien the job. This owner has been such a problem that if you file a lien, it's going to stop payment. I'm going to be paid next Wednesday. I will have your check on Thursday. Well, that's okay, right? Because you can file your lien within 75 days of the day that you were supposed to get paid. No, their 75 days was up on Friday before the Wednesday that the contractor is going to get their payment. So I said, have them call you back to do more work, give you a change order. And they gave them a change order. They went out and they did like half a day's worth of work. And they got a couple of things. They got paid just exactly how the contractor said they were going to be paid. But they also got the peace of mind that if they weren't paid, they could file a lien. And they got a very happy customer because they worked with them and made sure that they could have a lien-free job. You get paid, sign the right lien waiver. Make sure that you're getting your retainage or excluding retainage from the waiver. If you don't get paid, just file your lien. There's your time periods we were talking about. You may want to do that notice of intent to lien. Again, not required, but a good first step to get people to pay attention to you being paid. Once you get paid in full, then release your lien. Simple as that. And beware of a notice to commence suit. If there is, that's the one defense that that owners and contractors in the bank, pretty much anybody, can give you a notice to commence suit. There's a strict 60-day time limit on it. If you receive a notice of commence suit, the very, very, very first thing you want to do is talk to your lawyer, because you need somebody to get that on a 60-day time clock and be prepared to file a foreclosure action or lose your lien rights. So don't say, I'm going to lunch, I'll think about that later, because somebody's going to put something on top of it and you're going to think about it in 62 days. So pick it up, do your stuff with the lawyer so it can get a construction lawyer, so it can get served on time. Well, that wraps it up for today. I don't see any questions here. You've got my email address, but you also have my phone number. If you have any questions about this, I didn't answer anything or make anything as clear as you'd like, give me a call. Yeah, I'm not going to charge you for it. This is your shot to have your questions answered, particularly, it doesn't have to be just this program, but particularly if it's about something on this program. So I'll hand the microphone back to Rachel. And
thank you so much, Russell. Thank you. You provided us with very, very valuable information, and thank you so much for educating us on this very important topic. If you'll do me a favor and just go to the next slide. Okay, if you guys would like to take a moment to review us on Google, you can do that. And then if you'll go to the next slide, please, Russell. Okay, so our next webinars with Russell will be Thursday, July 13th from 9 a.m. to 9:20 a.m. And that topic is don't sign a release unless it says this one thing. And then after that, our next webinar with Russell will be on Thursday, October 12th from 9 a.m. to 9:20 a.m. And that topic will be what happens after I record my lien? How do I get paid? So feel free to register for these next two webinars at sunraynotice.com/education. And then if you'll go to the next slide for me, Russell. Okay, I hope everyone has a sunny day and we hope to see you on our next webinar. Thanks so much, guys.
Okay, thanks, Rachel, and thanks everyone for paying attention here.
Thank you, Russell. Bye, everyone.
Bye-bye.